adjusters to order. Roll call. Yep, roll call.
Debbie Murphy, planning and zoning.
Travis Harris, planning and zoning.
Ed Wilson, planning and zoning.
Ryan Cindy, Ward Two, planning and zoning.
Everybody present and accounted for. Get everybody stand for pledge allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Oh, but you would technically do that. Okay.
And I apologize for one thing, all accounted for, Nate Dakota is not really, he's in the hospital, so everybody that's available is appointed and available here.
First order of business is we need to elect a chair of the board. I'd like to make a motion to elect Ed as the chair of the Board of Adjustment.
I'll second your motion.
All those in favor?
Aye.
Aye.
Motion passed. Okay, so first order of business. You want to do that first?
Point of information, Mr. Chair, if we could point out that we have representatives of Guzman Law Firm here.
Okay,
My name is Alex Masteller, and I'm actually of the Rinke Noonan Law Firm, but representing Grand Park Capital in addition to the members of the Guzman.
okay,
Anna Limoges.
Andy Grocott, very second.
okay. And then we have John,
John Hughes, City Attorney.
all present, so, okay. First,
Well, there's a couple of ways we could do this. I want to mention and make a part of the proceedings, the affidavit cover letter dated January 6, 2023 from Assistant Attorney General Ann Mines Bailey, who works with the South Dakota Department of Agriculture and Natural Resources. And there's also an affidavit from Kelly Busher, who is the program administrator and is responsible for overseeing the clean water regulatory programs for DANR. I received this affidavit today from Kelly Busher with exhibits and also with two additional warning letters dated November 23 of 2022. And the DANR is indicating that they are commencing enforcement action. So I would like to make this part of the record of the proceedings. And I also have a copy of the joint meeting minutes with the certification of publication regarding the joint meeting on October 26, 2022, which the joint motion approved by the P and Z and the city council is the issue that we have before us for this meeting. So I would like to, if the board would please acknowledge by motion and second that those two documents are made part of the proceedings, the cover letter and affidavit and exhibits of Kelly Busher and the minutes of the October 26, 2022 joint meeting, please.
can I go first?
Sure.
Make a motion to add the affidavits and the agenda for the minutes from the October 26th P and Z and council meeting, the official record of the adjustment meeting. Is that satisfactory?
That is, and we'll call for a vote.
Second.
Second, all those in favor?
Aye.
Aye.
All those opposed? Motion passed. They're accepted to the meeting, to the hearing. Now, with that being said, with that stuff admitted from Kelly Busher, we've read it. We've seen what she says. And with this being reference to the joint motion of the, meeting with planning and zoning and Baltic for what was requested for where this hearing is opposed to, that between this affidavit and the school board meeting that Bob Siddick had and the statements he made there, the first and the third issue of that joint motion are now, we take that as being considered satisfied to move it. And then the second one, since it is technically hearsay, matter of opinion, we feel that we need to make that moot also at the time,
Everybody has their own opinion.
because everybody has their own opinion. So with that being said, if I could get a motion to grant first and third satisfied and mooting the second one due to it being matter of opinion.
And if I may, for those of us who don't have that in front of us, can you tell us what first and third is, please?
Yes, let me look at it here so I read it the same way. So small, I'm having a hard time hearing something. You got it, okay?
I doubt it, but why you have to find it.
Mr. Chair, I have another.
Oh, you got another copy of it?
It's larger.
Oh, thank you.
Huh.
That one is pretty small. He did call me.
Right there.
Right here, okay, yeah, so Ryan Siddig made a motion. Sindig. The first one was clarifying that it is that the state DNR requiring the developer to clean up of both the school and the city properties and future sediment downflow needs to cease. That's where the affidavit Kelly Butcher comes in stating that that was said by the state. We are just going by what the state said. The third one is that the developer will request the school to publicly retract their uniform and false statements regarding the city, specifically referring to the letter, which is where Bob Siddick in the school board meeting said that they were misinformed and not have all the facts. I don't have the exact wording he said with me, or we actually have a clip of the video. Do we have that clip of the video? Not here. So, with him doing that, it gives us the satisfaction for number 3. The second one was the one where we were, requesting that they clarify that the city's intent was to invoke their fiduciary responsibility to protect our taxpayers, public safety, and our city's environment. They must acknowledge that the city is neither anti-development nor do they wish harm on any present or future citizens. Which we feel that is matter of opinion after thinking about it, to where we want to move that statement out, calling the whole issue settled and resolved.
Well, because of the affidavit and the exhibits part of the record now. I'd like to make a motion that the previous letter is moot.
Motion. You said what?
Yeah, the motion is moot. Sorry.
Is it to retract the motion? Is that what you would be doing?
No,
Or is
we're
it
not retracting.
Just rendering it moot?
Yep.
Curious on
Well,
wording.
that's up to you, Travis. You're-
I'm just curious on wording.
You're the Board of Adjustment, so we want to have a public discussion, and that's what this is all about, so I encourage you to have that discussion.
I'm hoping that it's not retracted because 2 of the items were settled. The third one is the one that the second issue would be the only one that would be considered retracted. due to the fact that it's opinion.
Okay,
The first and the third one, they are considered settled.
Gotcha.
So we're making the whole motion moot.
And maybe I could add to the conversation here a little bit. Number one, the non-compliance with the joint motion on the part of the developer has no consequences. There's nothing in the minutes that states or provides that there are any negative consequences for the developer's failure to do those three things, which I think it's undisputed the developer elected not to do those. And so the concept of mootness means that something is no longer of any effect due to a change in circumstances. And I think not to put words in your mouth, Ed, but I think what you're saying is that given the established facts, that it is in fact the DANR that is requiring that these steps be taken to address the school district property, as well as Murphy's Pond, that there really isn't any point in continuing the life of this joint motion because its need is no longer present. So maybe I hope that's helpful. I'm not trying to lead anybody around, but I think that's what the point is.
That's a more technical description. Thank you, John.
So given that, Travis, I hope that's helpful to clarify.
Yes,
It,
great.
it is an unusual situation. A Board of Adjustment appeal on a matter that does not involve the issuance of permits or a conditional use permit is a little bit out of the norm. And yet we have a statute in 11-4-17 subsection 1, which clearly says that the Board of Adjustment is entitled to hear appeals where there is alleged to be an error in any order, requirement, decision, or determination made by an administrative official in the enforcement of this chapter or any ordinance adopted pursuant to this chapter. And so clearly, and you know, I've given you my advice that this matter does fall within the Board of Adjustment. It also falls within the purview of the Lamar decision that was decided by the South Dakota Supreme Court in June of 2020 at 2020 South Dakota 30. So we've got all these legal issues to deal with, but yet we have a notice of appeal that was filed such that only the joint motion was within the lifetime of the 21 days in which the developer had to appeal to the Board of Adjustment. Now, there's pending litigation. There are 2 pending lawsuits developer has brought against the city on November 23. And ultimately a judge would decide who had authority to do what. So I don't view, and counsel for Grant Park Capital may beg to differ, but I don't see how the Board of Adjustment can make a decision on what the legal authority is for anything, because that matter is actually in front of the judge right now. But this board certainly has all the authority in the world to say that, you know what, we're not going to do anything with respect to this joint motion in the future, because the need for it and the rationale for it is now moot in view of what the state is doing. State is going to enforce these stormwater permits. So does that help you? Okay.
Thank you, John.
I'd like to make a motion that the joint motion is now moot and we can move on from that.
There's no first. You got a second?
A second?
All those in favor?
Aye.
Aye. All those opposed? Motion granted. That's taken care of. Now we are here to hear a presentation from,
And all of those things that just occurred there, it doesn't, it changes somewhat what our presentation, but it doesn't change it in entirety. Our purpose tonight was primarily procedural. We're not here to discuss the facts. I don't think that's a proper venue to discuss, the
Yep.
facts of the matter. Our position has been that this appeal process that we're sitting here before you today needs to start with a decision from an authorized official. And that's pursuant to the statutory framework that Mr. Hughes just cited, and also your ordinance. The joint motion and all of the activities that culminated in the joint motion, there was not a decision by an authorized official that would then necessitate an appeal to the Board of Adjustment, which you are. And so all I know how to do as an attorney is read. I don't know anything else. And so when we look at your ordinance in section 1705, says any person aggrieved by any decision of the Board of Adjustment may petition a court of record within 30 days after filing of the board's decision as provided by South Dakota Codified Law 11-4-25. When we got the joint motion, that was a decision of the Board of Adjustment, but also is a joint motion, right? So it's a decision of the city. You guys aren't here tonight to do anything with the city's portion of that motion. So
that was not a motion of the Board of Adjustment. That was planning and zoning as well as the city council. Board of Adjustment isn't until now. So when we're planning and zoning, that's a separate entity. Okay, when it goes to planning, when it goes above that decisions to the Board of Adjustment, that is this board. It may be same people, that doesn't make a difference. At that time, everybody, if you look at the minutes, was introduced as planning and zoning and city council.
sure.
Nobody was introduced as Board of Adjustment.
Okay.
So everything you said, we hear, but it's not correct. Because we were not there as Board of Adjustment.
Okay. And so I guess that still begs the question of, was there a decision made by an authorized official? And again, maybe this is all, I'm just saying what our position was tonight. And it's not about the facts of what's on the ground outside town here. It's on just the process.
And who decides who an authorized official is? Because-
It's contained in your subdivision.
Yep, no, I said who, not what, who decides who the authorized official is, because the mayor was voted in. We have John Hughes, our city attorney, that was present, appointed as the Board of Planning and Zoning. Everybody on city council was elected by the citizens of the town. So as far as who was the authorized person, there were several authorized people. You got the mayor that was elected, we got city council members that were elected, we have planning and zoning members that were appointed and approved by the city council who were elected by the taxpayers. So as far as an authorized person, which person do you want me to say?
Well, it's actually a requirement of your ordinance and of the statute. There has to be an authorized official. There's not multiple.
To make that one motion decision? No, okay, so
I'll read to you from.
no, I know what you said, but my question is you're asking who the authorized official was to make that motion, to pass that motion.
No, I'm saying there was no decision made by an authorized official. And therefore, this appeal process that we're describing right now, we question whether it was necessary. We're glad to be here to talk about it, but we don't believe that this appeal process maybe would have even been triggered.
If I could make a point of information or point of order, Counselor, we're here because of the notice of appeal that you and your colleagues filed on behalf of Grant Park Capital. And so the only reason we're here is because on November 10, you filed a notice of appeal and you appealed essentially over the joint motion. So we're here because of you.
Yeah, I don't disagree. We've done what's called, what I would consider sort of a belt and suspenders approach, because this process has been, it's been not clear necessarily as to what points we are in a process. And so when the motion came out, we determined to do everything under the sun on which to combat it. And the notice of appeal was just one aspect of that.
The building inspector, who generally would have been the authorized official, resigned without notice, did not continue providing any services after the May meeting. And the city faced a emergency situation because the entire staff of the city, the exception of the city administrator, resigned without notice. And so literally I don't, I'm not going to argue the law with you. I guess the question you're asking is, you're raising the question of whether or not a planning and zoning commission can, as a group, exercise the duties and powers of the authorized official under the ordinance. And that is a question you're certainly capable of raising that, and probably in a different way, perhaps framing it up in one of the two court cases that are pending. You can argue that point to the court for whatever significance you think it has, but I guess I would beg to differ that a planning and zoning commission, for example, can't sit and exercise the plenary powers that are granted to municipalities in STCL Chapter 11, 4, which are exhaustive plenary powers. And so, but if you want to argue that, we can do that in court.
No, and that's fine, Mr. Hughes. That, I mean, you can gladly have that opinion and give advice to your client. I'm just raising the issues before the board today. I mean, that was one of our bases, is to request the basis for the joint motion. But we just heard that the joint motion is going to not take effect from the Board of Adjustments perspective. There still is the city, and I wouldn't expect that you guys have any ability to do anything on part of the city.
It's been removed.
We have two council members here, sitting here, and we have a meeting coming up on the second Tuesday of the month. So maybe you want to come to that meeting if you have a specific request to make. I think if the Board of Adjustment is telling you that joint motion is moot, I think that you can deem the joint motion moot. It has no consequences. It never said that unless the developer does these things, X, Y, and Z are going to happen or not happen.
But it was said verbally at the meeting.
Well, and fine, but minutes are minutes, and they're official minutes, and they stand as the official record of the city under state law. And so if you want to argue that point, I guess that's another point to bring before the court if you wish. It's not in the minutes. There have been no consequences that have been attached to the joint motion. And, frankly, I would think that the developer would take this as a gesture of, let's put the past, I keep hearing, let's put the past behind us. Well, now this Board of Adjustment is trying to put the past behind us. I mean, the developer still has not posted a bond as the subdivision regulations would require. We have way bigger issues to fight about than what mootness means, or whether this council will pass a corresponding resolution, which they may do.
With that being said, John, so with your question about the authorized person, right? So let's ask this question. We have a document that's admitted, signed affidavit is from the head of the VA, Kelly Busher. That makes the first thing true, right? We asked the developer to say that this was true. Has not done it yet, right? We asked them to say that we're not anti-development because anti-development, okay, that means we don't care and we let you do whatever you want, not follow the rules. Proper development is proper development. It's done in Sioux Falls, it's done in Garrison, it's done in Dale Rapids, it's done in Harrisburg, it's done in T. Okay, it's called proper development. That's why you have that book of ordinance and regulations that we ask them to follow. Which one of them is the SWIP form that we have a signed testimony here, affidavit stating that you're not doing as a developer. Okay, third one, the school board, we asked the developer to ask the school board to tell them that they didn't have all the facts before they spoke. We had the school board at a planning and zoning meeting. We confronted them, we solved the issue, everything was taken care of. There was a school board meeting, he said in the school board meeting that they did not have all the facts, they spoke wrong. Okay, we asked the developer to say the truth, not lie, not say something that isn't the truth, something that we just presented sworn documents stating is the truth. So if we back up 2 steps, if the developer would have just said, hey, we made a mistake, this won't even be here right now, would it not? That's all we asked. Now you're asking about authorized personnel. Well, as the authorized personnel resign, that automatically puts that power to planning and zoning. Because there isn't an authorized person because they resigned. And until somebody's appointed, it is the duty of planning and zoning to make sure the regulations and the rules are followed. Okay? You have never followed any rules. You're suing the city because you're not following rules. That in fact, one of the members of Grant Park's dad wrote the rules. So let's just make it simple. Follow the rules. This meeting can be adjourned at any point in time. Because there was nothing else to discuss. The motion's gone. You were here for the motion. It's settled besides the fact that your party did not want to admit the truth. We have other forms that say it's true. Anybody, motion for adjournment, please?
Are you gonna not allow us to speak anymore?
Don't need to.
Our questions were primarily about the process.
We're done.
I'd let him talk.
Okay,
I mean,
Okay,
the
We're
questions were
here, like
about
you
the
said, to
process.
argue about the facts. Okay, what he was trying to say, and I think John kind of pointed out, was this is an unusual situation to have this kind of appeal in front of you.
yep,
This isn't a permit, this isn't a conditional use permit, nothing like that, so this is unusual.
it is.
Our appeal to you was essentially, the boot and straps, right? Suspenders,
Yeah.
and to ask you guys, do you think that we should be here today, for one?
No, we shouldn't be here today because your party should have already done this, so it was already resolved weeks ago.
So,
Well,
so, our first step was to be like, hey, we did all the things, we did our notice of appeal, we filed the lawsuit. We didn't know for one if there was an authorized official, so that was the question, you answered that question. 2, it's a joint motion, okay? We have P and Z members and we have city council members. Allegedly, the city council will take effect later or whatever and do the same thing that you're doing. We still need something that says you guys have a right to do this motion and grant this motion in the first place. What you're doing here is rendering it moot, saying that it's satisfied, right?
yep,
And some of it is, and that it's moot, right?
Yep.
So you're saying that he did the cleanup and,
no, we did
No.
not say he did anything because he has
Oh,
not
I heard the
done
word
nothing.
cleanup done.
No, it's
That
not
was
done.
Okay.
No, they've done absolutely nothing, hence the reason why they are now going to get fined and underneath, deals from the DNR because it's now past that point.
So I will tell you, they've been threatening enforcement since August.
You
It's
do
part of-
realize, yep, and you do realize it goes back from the initial
Process.
date, right?
So
You know,
if you could, realize that we have been working to be in compliance, that affidavit is not full.
really?
We do have a supplemental one coming, but if you want to base your decision on an incomplete affidavit, that's fine. I would
Oh, wow.
recommend that you look instead of that at the whole notebook
But,
because.
but John, hey,
Let
John,
Council, listen to me.
you're off point.
Listen to me, the Assistant Attorney General of South Dakota wrote that affidavit. She wrote it this.
The assistant,
okay, let John.
Well,
saying, if I would pay attention to the inspection reports as well.
I would like to hear from the city attorney, please. Please.
I guess council, my problem is that this is all argumentative. And it's pointless. It doesn't, this is your authority. This is your duly appointed Board of Adjustment, which frankly, under the Lamar case, our opinion is that the Board of Adjustment supersedes the council's action. That's our interpretation of the Lamar case. Now, why are we having this conversation? Because it's dealing with legal issues. I asked the state of South Dakota, DANR, if they would prepare an affidavit in connection with this hearing and the litigation. That's what was produced. I made virtually no comment to it at all. And so I was in touch with Assistant Attorney General Ann Bailey today. You can say whatever you want to, but they authorized that affidavit and all the exhibits to be released so that we could use it in the two litigations and for purposes of this Board of Adjustment meeting. Now, if you can sue the state if you'd like. If you have a problem with how Kelly Busher and the DANR is handling this, that I think you're all creative enough to find a way that, you know, maybe the state has some liability to you. But under oath, we have the program coordinator for the Clean Water Act enforcement, the professional engineer Kelly Busher, under oath stating that they are commencing enforcement action. Now, unless you want to call her as a witness and impeach her, that'd be fine, but it's going to have to be in a courtroom. And this isn't the place for that.
So that's
Thank you.
not
I
what I'm
appreciate that.
saying. I'm saying there is stuff in that binder there that talks about what our developer, what our client has been doing to come to compliance.
Oh, I've
So
read
if-
it all.
if-
I've read every bit of it,
Then that-
and he's never completed nothing.
but the-
So we're not on point no more. We're talking about a motion,
Yeah.
nothing about what he has not done or done, because he hasn't done it. So let's just put it to rest. It's done. You came here to ask a question where the authority is. We just told you where the authority is, right?
So will that be in the written decision on Monday?
About what? Which part of the written decision?
Well, you guys still have to come up with a written decision as to what authority.
We just told you.
Counsel, that is not,
Will be.
that is not a legal issue. You can petition the court and argue that there's a lack of authority, but I emailed you a month ago, counsel, more than probably 6 weeks ago, and directed your attention to SD cell 11-4-7.
Just following the appeal process, Chuck.
I don't know how that's following up the appeal process. You will get your written decision on Monday, and
That's all I want.
we're well aware, we can all count 60 days.
Yeah.
And you don't need to tell the Board of Adjustment when the deadline is for their decision. We'll have it on Monday, and it's gonna say that there's gonna be a finding entered that the joint motion is moot. That's what it's going to say. And you are free to take your case, if you want to continue the litigation instead of pursuing development, that's fine. That's your client's choice. And he's got 4 lawyers here that certainly.
Well, 3 now, 1 left because they,
Got her performance.
Oh, well, I'm sure he's, you know, gonna be filled in, and so, but I certainly don't view this as a productive.
No, our questions were about process. I think those have been
Exactly
answered.
right.
So I think that's.
I have a telephone,
see,
Ms. Lamoch. I have
As
a
this,
telephone that I answer.
I knew where this was going,
If you want to know who the authorized.
because I read all her emails.
It's no
So
problem.
I didn't need a verse. Because she said exactly what she says in every one of her emails that she sent. It's the same thing. Repetitive litigation of trying to bully people into making a mistake, so something is done that they can fight it. I see litigation emails that you send, okay, because obviously you can see I'm on all of them copied. So it's, we know where the process is. So with everything being done, I need to make a motion to adjourn the meeting.
Make a motion to adjourn.
I will second.
All of in favor?
Aye.
Meeting adjourned. Thank you.